Hi viewers, greetings of the day to all of you. We welcome you on behalf of NRI Legal Services. As you know, NRI Legal Services is a premier global firm which is handling property matters of NRIs all over India. We have been holding Ask Me Anything sessions in the past also to benefit the NRI friends so that we can answer their queries on various topics. And in that pursuit, we are here in front of you to conduct another session of Ask Me Anything. You are welcome to ask queries on the today's topic, that is legalities involved in the property matters of NRI. If you have any property matter issues in India regarding your properties, you are most welcome to shoot your queries. We are here to answer your queries. I will be assisted by my team while answering to your queries. As you know, I am Col Jatinder Singh. I am the Vice President NRI Legal Services, and on my left is
Advocate Dinky, Legal Associate, NRI Legal Services.
And on my right is
Advocate Dipinderjeet Kaur, Legal Associate, NRI Legal Services.
So thank you Advocate Dinky and Advocate Dipinder for joining me for this session. And during this session, as I told you, we will be handling all the issues pertaining to NRI properties, legalities involved therein. You know, we have seen the NRIs are having a large number of properties in India. And these properties are generally unattended most of the times, and sometimes if they're holding properties, they are either co-owners in those properties, or they have trusted those properties to the caretakers, or some relative or friend or people are taking care on behalf of the NRIs. So during this, lot of problems are faced because NRIs are not able to visit very often to India. So sometimes the caretaker or the relatives and other people who are trusted with the properties may take over the illegal possession of the property and may not part with the share of the NRIs which they have in those properties. We have seen that generally the properties are either self-acquired properties or ancestral properties. For example, if a NRI has to get the property partitioned, the partition of the property has certain legalities involved. You may not be knowing the procedure, how I should get the property partitioned, how should I proceed about it, how can I get my share demarcated. So you have to see that when you have to get the property partitioned, there are various procedures involved. Because if it's a residential property, there's a different procedure. If it is a agricultural property, there's a different procedure. You have to approach different courts of law. So far as agricultural property is concerned, in Punjab, for example, you can say that you have to approach the revenue court. And if you are approaching the revenue court for that partition of the property to get your property demarcated from the other co-owners, then you have to file a proper application along with the relevant documents, and then the revenue authorities, which is the district revenue officer of that court, who is considered to be the judge of that court, he after considering all the issues before it, decides upon the partition, and then your property can get demarcated. And once the property is demarcated, then you can take over the possession of the property. Then it becomes your separate share of the property in the property which is co-owned by various people. Now further moving on, any questions have come?
Yes, sir, we have a question.
Okay, Dipinder, just you read the question.
Okay, we have a question that is, I am a citizen of UK. We are 3 brothers and 1 sister. We have ancestral property in Himachal where my father made a will in favor of my elder brother, giving him the full ancestral.
Don't worry, just read it.
Should I read it, sir? Yeah. The question is, I am a citizen of UK. We are 3 brother and 1 sister. We have ancestral property in Himachal where my father made a will in favor of my elder brother, giving him the full ancestral property. My father passed thereafter in 2018, and now my elder brother has gifted some portion of the property to my younger brother and is not providing me any share in the said ancestral property. The property was further inherited inherited by my father from my grandfather. Can you advise what can I do?
So may I answer this question?
Okay, please go ahead.
Thank you, Sukhvinder ji, for your question. So first of all, I would like to clarify you that the ancestral property cannot be transferred by way of will, because in an ancestral property there are legal heirs, and each and every one in that ancestral property has a legal right by birth, including the daughters. So in your matter, where your father has made a will bequeathing his share in that particular property to one of your elder brother, in that case that will is not legally sustainable. So in this case you can challenge that particular will. Subsequently, the gift deed which has been given by one of your brothers to one of your another brother, this is also not legally sustainable. So in this case you can approach the court of law and you can challenge the gift deed as well as the will, and you can acquire your share in that ancestral property. So I hope your query is clear.
Oh, it is clear. Thank you, Dipendra. The only issue which is very relevant here is that the ancestral property, you cannot make a will, because ancestral property, a person gets the birthright by birth. Even Hindu Succession Act had been amended in 2005. Earlier, the girl child never used to have a birthright in the ancestral property, but now after that amendment, even the girl child has equal right in the ancestral property. Any other question?
Yes, sir. We have one more question.
Okay.
I am a resident of US. I have a residential property in Gujarat. The property is located in Surat. I am 50% owner of the property. The balance 50% is owned by my brother. My brother is staying in the property. I had approached my brother for partition. He has not paid any heed. How can I get the property partitioned?
Okay, I will handle this question. As I was telling you that now the property is located in the state of Gujarat, right, in Surat, and you are 50% owner of the property. You say that the balance 50% is owned by your brother, and your brother is staying in the property and he is not giving you your share. In the state of Gujarat, and the property if has to be partitioned, then the only way to get the property partitioned is by approaching the civil court. In this case, you can always sue your brother and ask for your share in the property, because first of all, you are the owner of the property. You should be having the ownership documents which is showing your right in the property. Then the success of your suit are 100%. If you are clearly depicted as 50% owner of the property, the same can be claimed through the process of the court of law. Any other question?
Yes, sir. We have another question. I am resident of UK. I entered into an agreement with the developer and purchased a flat in the under construction project in Delhi. The developer assured me that they would hand over the possession of the property within 2 years from the date of the agreement signed. However, it has been 5 years since they have not provided me the possession, and I have paid the full amount towards the same. What should I do? Sir, may I handle this question?
Okay, please go ahead.
Okay, thank you, Sumanji, for your question. So, I would like to tell you that since you have purchased the property and the developer has till date not given you the possession, in this scenario, what you can do is you can file a consumer complaint against the developer in this regard before a special body which has been constituted for this purpose, and it deals with the real estate projects, which is known as RERA, that is Real Estate Regulatory Authority. Or else what you can do is you can file the consumer complaint against the developer in the consumer court as well. So by filing these complaints, you can get back your relief, that is you want from the courts, that is the refund, damages or compensation from that particular court for the same.
Okay, just let me clarify one thing here. If you are approaching the RERA authority, that is Real Estate Regulatory Authority, then your property must be registered under the RERA. If the property is not registered under RERA, then RERA may not entertain that complaint. You will have to go to the consumer court, because it's a deficiency in service, so your consumer complaint is sustainable before the Consumer Commission. The jurisdiction also I would like to clarify here that the Consumer Commission has specified jurisdiction depending upon the value of the property and the damages being claimed. And to that effect, the District Commission has jurisdiction up to 1 crore rupees, and the State Commission has jurisdiction from 1 crore to 10 crore, and beyond 10 crore the jurisdiction is with the National Commission. So keeping in mind these few lines, you can approach the concerned RERA authority of Consumer Court as also explained by Advocate Deepinder. I hope your query is answered. Thank you so much. Any other questions?
Yes, sir. We have one question. Greetings, sir. I am a resident of Australia. My brother and I had executed a family settlement agreement in respect of 3 properties jointly owned by us. In that agreement, we had mutually divided the property amongst ourselves, but now he is denying to accept the terms of the agreement. What remedy is available? Sir, may I answer this question?
No, please answer.
So thank you so much, Parul, for your question. With regard to family settlement agreements, these agreements are generally formed among family members in order to resolve the disputes that are related to the properties that are jointly owned by them. So if a family settlement agreement is formed between you and your brother has given his consent to the family settlement agreement, he cannot deny it, or he cannot deny the terms of that agreement regarding the division of the property. The Indian courts have also time and again upheld the validity of the family settlement agreements, because if a party is consenting to an agreement, he cannot at a later date either deny it or challenge its validity. So in this case, if your brother is still denying it, you can approach the court of law and get the family settlement agreement executed, and then you can claim your share in the property according to the terms of those agreement.
That's right. So family settlement agreement is clearly enforceable in a court of law as brought out by Advocate Dinky. Any other question?
Yes, sir, we have another question. ਹੈਲੋ, ਮੈਂ USA ਵਿੱਚ ਰਹਿੰਦਾ ਹਾਂ। ਮੇਰਾ ਜੱਦੀ ਘਰ ਪੰਜਾਬ ਵਿੱਚ ਹੈ। ਅਸੀਂ 4 ਭੈਣ ਭਰਾ ਹਾਂ ਤੇ ਮੈਨੂੰ ਛੱਡ ਕੇ ਸਭ ਪੰਜਾਬ ਵਿੱਚ ਹੀ ਰਹਿੰਦੇ ਨੇ। ਮੈਨੂੰ ਪਤਾ ਲੱਗਿਆ ਹੈ ਕਿ ਮੇਰਾ ਜੱਦੀ ਘਰ ਉਹ ਸਭ ਪੰਜਾਬ ਵਿੱਚ ਵੇਚ ਰਹੇ ਹਨ ਤੇ ਮੈਨੂੰ ਮੇਰਾ ਕੋਈ ਹਿੱਸਾ ਨਹੀਂ ਦਿੱਤਾ ਜਾ ਰਿਹਾ। ਮੈਂ ਇਸ ਵਿੱਚ ਕੀ ਕਰ ਸਕਦਾ ਹਾਂ? ਸੋ ਮੈਂ ਹੈਂਡਲ ਦਿਸ ਕੁਐਸਚਨ? ਪਲੀਜ਼। ਹਾਂਜੀ, ਮੈਂ ਤੁਹਾਨੂੰ ਇਸ 'ਚ ਦੱਸਣਾ ਚਾਹਾਂਗੀ ਕਿ ਜੋ ਤੁਹਾਡਾ ਜੱਦੀ ਘਰ ਪੰਜਾਬ ਵਿੱਚ ਹੈ ਉਹ ਉਦੋਂ ਤੱਕ ਨਹੀਂ ਵਿਕ ਸਕਦਾ ਜਦੋਂ ਤੱਕ ਕਿ ਸਾਰੇ ਹਿੱਸੇਦਾਰ ਉਸ ਜੱਦੀ ਘਰ ਨੂੰ ਵੇਚਣ ਵਿੱਚ ਆਪਣੀ ਰਜ਼ਾਮੰਦੀ ਨਹੀਂ ਦੇ ਦਿੰਦੇ, ਕਿਉਂਕਿ ਜਿੰਨੇ ਵੀ ਲੀਗਲ ਹੇਅਰਸ ਉਸ ਜੱਦੀ ਘਰ ਵਿੱਚ ਹੈਗੇ ਨੇ ਉਹਨਾਂ ਸਭ ਦਾ ਉਸ ਘਰ ਵਿੱਚ ਬਰਾਬਰ ਦਾ ਹੱਕ ਬਣਦਾ ਹੈ। ਜਿਵੇਂ ਕਿ ਤੁਸੀਂ ਦੱਸ ਰਹੇ ਹੋ ਕਿ ਤੁਹਾਡੇ 4 ਭੈਣ ਭਰਾ ਹਨ ਤੇ ਉਹ ਤੁਹਾਡੀ ਬਿਨਾਂ ਰਜ਼ਾਮੰਦੀ ਤੋਂ ਘਰ ਅੱਗੇ ਵੇਚਣਾ ਚਾਹੁੰਦੇ ਨੇ, ਤੇ ਇਸ ਕੇਸ 'ਚ ਕੀ ਹੋ ਸਕਦਾ ਹੈ ਕਿ ਜੇ ਤੁਹਾਡੇ ਭੈਣ ਭਰਾ ਤੁਹਾਡਾ ਉਹ ਜੱਦੀ ਘਰ ਬਿਨਾਂ ਤੁਹਾਡੀ ਮਨਜ਼ੂਰੀ ਤੋਂ ਕਿਸੇ ਗੈਰ ਕਾਨੂੰਨੀ ਤਰੀਕੇ ਦੇ ਨਾਲ ਵੇਚ ਵੀ ਦਿੰਦੇ ਨੇ, ਤਾਂ ਤੁਸੀਂ ਕੋਰਟ ਜਾ ਕੇ ਕੋਰਟ ਤੋਂ ਆਪਣਾ ਉਸ ਜੱਦੀ ਘਰ ਵਿੱਚੋਂ ਆਪਣਾ ਹਿੱਸਾ ਮੰਗ ਸਕਦੇ ਹੋ ਤੇ ਉਸ ਸੇਲ ਡੀਡ ਨੂੰ ਵੀ ਤੁਸੀਂ ਚੈਲੰਜ ਕਰ ਸਕਦੇ ਹੋ ਤਾਂ ਕਿ ਤੁਹਾਨੂੰ ਤੁਹਾਡਾ ਹਿੱਸਾ ਉਸ ਜੱਦੀ ਘਰ ਵਿੱਚੋਂ ਮਿਲ ਸਕੇ। ਹਾਂਜੀ,
that's right. Okay, any other question?
Yes, sir, we have one more question.
Okay.
I am a resident of UK. I entered into an agreement with the developer and purchased a flat in their under construction project in Delhi.
I think we have covered this question.
No.
Okay, so
we have covered this question.
We'll move on to the other. I am a resident of US. This one's also covered.
Yes, we have covered this. The next one.
Okay, I have taken an apartment on rent recently and a proper rent agreement was prepared by the landlord. Within 1 week
What for this question? Samir?
Yes,
Samir.
Okay.
Should I read it again?
Yeah, please.
Okay, I have taken an apartment on rent recently and a proper rent agreement was prepared with the landlord. Within 1 week of my taking over, my water and electricity connection has been disconnected by the government authorities and asked me to pay the dues. I approached my landlord for the needful, but he has denied and asked me to make the payment if I wanted to continue in the apartment. What should I do?
Okay, let me handle this question. It's a very peculiar situation. Mr. Samir, let me clarify to you that if you have already moved in the apartment and the landlord has given you the entry and now the government has disconnected the electricity and water connection, so it is obvious that the previous occupant, previous tenant or the landlord himself has not cleared all the dues which he should have paid while handing over the house to you. That is all the electricity charges and the water charges which were due to the government. So government is well within their right to disconnect, but since you have to enjoy the property and you have to pay the rent to the landlord every month, my advice is that you do not pay the rent for this month and clear the dues and continue to enjoy the property, because in the meanwhile whatever rent accrues by you towards the landlord, you can deduct that amount from the rent which is accrued towards the landlord, and then you can enjoy the property. One thing I would also let you know, you must ensure, or any tenant who is entering into a property must ensure that whenever you enter in a property, you must check the electricity bill, the water bills, and also the connection, the meter reading of the electricity meter and the water connection meter, and so that you have to pay the money or the rent or the dues towards that electricity and water charges for the period of occupancy and for the period you have used that electricity and water. I hope you are satisfied with this. Any other query?
Yes, sir. We have another query from Munish Kumar. Dear sir, I have a house in Chandigarh and I had rented it in 2011. Since then, my tenants are residing in the house. In 2019, I had asked them to vacate the property as I wanted to sell it, but they refused. I had also sent them a notice in the same year, but they have not vacated it. Since then, they are threatening me that if I will ask them to vacate the house, they will file a case against me and will claim adverse possession. Can they do so?
So, should I answer this question?
No, please go ahead.
Okay, so according to the law on adverse possession in India, the first and foremost condition that has to be complied with in order to file a claim for adverse possession is that the possession should be peaceful, undisputed and continuous for a period of at least 12 years. Now, since you have mentioned that you had sent a notice to your tenant in 2019 and had asked your tenant to vacate the property, it clearly shows that the possession was not undisputed or it was not peaceful. So in this case, the claim for adverse possession will not be justified, and since the period of 12 years has also not lapsed, he cannot file a claim for adverse possession. So according to me, it will not be valid in court of law.
That's very right, Advocate Inky, you have brought out. This gentleman will never succeed if he files a case of adverse possession against you, because the adverse possession has brought out minimum 12 years period is required, and it has to be peaceful, it has to be continuous, it has to be without interruption. And one more thing I want to add here, that it has to be hostile. It should be obvious possession. That means that it should be clear to the public that this person is occupying the property for more than last 12 years and no one is interfering in that possession. And to that effect, the Honorable Supreme Court has also held that earlier the right of adverse possession could be used only as a shield, but now it can also be used as a sword, which means that earlier you were only protecting your right, but now you can claim the title over the property even if you are holding the property by way of adverse possession. So adverse possession, if all the elements are complied with, then that permits you to own that property and claim the title over the property. But in your case, it is very clear, it is very obvious that even the period of 12 years has not passed, and also the property is not coming under the purview of adverse possession. Any other question?
Yes, sir. Should I?
Okay, please.
Okay. We have a question from Aditya. I am a citizen of Singapore. However, I wanted a property in Mumbai and approached a builder in a renowned society of Mumbai to purchase a flat. I had made the entire payment towards the flat. The builder had promised me that the possession will be given by March 2021. A year has elapsed, but I have not been given the possession by the builder. What is the possible solution to it? Sir, may I answer this question?
Okay, please.
Okay. Okay, Aditya, as you have paid the full amount towards the property which you intended to purchase, and till date the developer has not given you the possession, so we can clearly see that the developer has violated the terms and conditions of the agreement. So, under these circumstances, what you can do is you can approach the appropriate court of law, and here you can claim the refund of the entire amount which has been paid by you along with interest, as the developer here is answerable and is responsible for the deficiency in services which he has provided to you. Or else what you can do is you can ask, you can seek the directions from the court to get the possession on priority, or else with that you can ask for the compensation for delay in delivery of that particular property. So in this way you can get either the possession or you can claim the refund from the developer. I hope your query is clear.
That refund can also be claimed with interest, and also the damages can be claimed since the possession has been delayed by the builder. That also can be part of your prayer. Right? Thank you so much. Any other question?
Yes, sir. We have one more question.
Okay.
I am presently residing in US. The father of my friend has recently expired, leaving behind property in Chandigarh in India. His father has not made any will. His father has left behind his wife, 2 daughters, and my friend. Are the sisters of my friend entitled to any share in the property of his father?
Okay, let me handle this question. In this case, it is obvious that the property belonged to your father, and now your father is not there, and he has also not left any will. Since he has not left any will, it being his self-acquired property, it has to be equally divided amongst all the legal heirs. Now, the sisters of your friend are one of the legal heirs, and as per the Hindu Succession Act, they have equal right in the property, and those 2 sisters having equal right, you cannot deny the right to them unless they are willing to surrender their right to you. If they want to surrender their right, they can surrender their right by way of relinquishment deed. Otherwise, if you intentionally don't give them their share, they can always sue you in a court of law. So those 2 sisters, your daughters of your father, friend's father, have equal right in the property. I hope it is clear. Any other question?
Yes, sir.
Should I read the question?
Yeah, sure.
Okay.
Okay. Next question is from Chiranjeev. I am resident of UK. I have 80 canals of land, but the said land has not been partitioned till date. In the same cavert of land, there are other co-owners who are my relatives. I want to get my land clearly demarcated by the way of partition. Please advise.
Okay. What's your name? Chiranjeev.
Chiranjeev.
Okay, Mr. Chiranjeev, let me clarify to you that this is agricultural land. It is 80 canals of land existing in one cavert, and I presume this land is in Punjab because generally caverts we call in Punjab only. So if this land is located in Punjab and there are other co-owners in this property, then the only way to get this property partitioned or to get your share in that property clearly demarcated is by way of approaching the revenue authorities. The revenue authorities who are dealing with the NRI cases is district revenue officers, or in short it is a DRO court, and this court you have to approach through an application. You can entrust the property lawyers in India who can handle your case on your behalf. You can even give power of attorney to your trusted people, and then this application is filed in the court of law, that is before the revenue authorities. And revenue authorities, after complying with the due procedure of law, which is a lengthy procedure, it takes a lot of time to get the things decided there also, but not as long as the civil court, but certainly little better than the civil court and less period than the civil court. And then based on the case which is put up to the revenue authorities, and after seeking the objections from the opposite party, if any, then they decide upon the process of demarcation. And generally the process of demarcation is decided upon the basis of various types of maps which are presented before the authority, and that can be done even up to your full satisfaction and what part of land you want, and also after seeking the views of the opposite parties. And moreover, when the revenue authorities pass clear orders regarding the demarcation of the land and the partition order is given, then you have to do the kabja karwai. That is, you have to take over the possession, which is again done by the same authority and by way of simple application which is filed, and then they can pass the order for the kabja. That is the possession to be taken of that property. I think this is the simplest and the easiest way to get your property demarcated through the process of court, which is legal. That's all. Any other thing? Any other question?
Yes, sir. I am a resident of South Africa. My father had purchased a house in Kolkata in 2010 and now he wants to sell it. I want to claim a share in his house as his legal heir and have asked him not to sell it. He is not listening to me. Can I file a case against him? So, may I handle this question?
Please go ahead.
So, legal heirs during the aliveness of a person cannot seek a claim in the self-acquired property. Since you have mentioned that your father had purchased the land himself in Kolkata in 2010, he has the complete right to sell it and use the proceeds in whatever way he wants. So, as a legal heir, you cannot claim any share in the self-acquired property. So, according to me and as per the law as well, the claim will not be justified.
That's right. So you don't have any right in the self-acquired property of your father because he is competent to dispose of the property as per his wishes. Unless he has made a will, otherwise you cannot claim the right in the property. If your name is there in the will, you may ask the share as per the will. Otherwise, you are not entitled to any share in the self-acquired property of your father. So he is at liberty to give it to anyone. I hope it is clear. Your query is answered. Thank you so much. Any other question?
Yes, sir. We have one more question from Udit Gupta.
Okay.
My friend's father died 5 years ago and he had multiple agricultural lands in Vadodara. His mother had also died and he is the only child. He wants to get these lands in his name. However, he does not know how many lands are there. Please suggest and how can he get the search conducted?
So, may I handle this question?
Please go ahead.
So since your friend's father had died in Vadodara and your friend is not aware about how many parcels of land were owned by his father, in that case you will first have to consult property lawyers who have expertise in this field, and they will conduct a proper title search. So once the lands are identified in which his father is reflected as the owner, your friend will then have to apply for a succession entry before the concerned revenue authorities. For this, certain important documents are required, such as the death certificate, and on the basis of those documents, a PD Nama is executed. So once the PD Nama is executed, an uncertified entry will be passed by the revenue authority, and if no objections are received in respect to those uncertified entry within a stipulated period of 60 to 90 days, the entry will be certified and your friend's name will be reflected as the owner in the revenue records. So this will be the procedure.
Right. That's good. I think everything is sufficiently explained. Any other questions?
So we have one last question here of Jitesh. I am UK resident and he had ownership flat in Rajkot for a number of years. If I want to sell the flat, can I sell the flat without going to India? If so, how?
Okay. I can handle this question. Jitesh, the property is in your name. You are owning a flat in India and you want to sell this flat. It's very easy to sell that flat. You can approach a property lawyer who is expert in this field, who are well experienced. Those property lawyers can manage to sell your flat easily, and this can be done by entrusting authorizing person by giving him a power of attorney. If you give power of attorney to your interested person, then that person can do all the formalities concerning with the selling of the property, and then after selling of the property, whatever proceeds are there from that property, those proceeds can also be repatriated to you sitting in UK itself, and all this can be done by experienced property lawyers, and it's very easy to get it done. I hope your query is answered. Any other query?
So I guess all the questions have been answered.
Okay. So, ladies and gentlemen, we see that there are large number of issues involved in the property matters of NRIs, there are sort of a lot of legalities which were involved. On these legalities have been discussed, clarified to you, and we see that the NRIs are having problems in disposing of their properties, getting properties partitioned, getting properties transferred, or they are also having consumer issues where they have been cheated by the builders who have not given them possession in time. And also there are a lot of landlord tenant disputes going on pertaining to the NRI properties. The tenants are possessing their properties, not vacating their properties, and even the case of adverse possession I have seen during this discussion, that properties are adversely being possessed or they are being threatened. So there are large number of issues we see that pertaining to the NRIs. So our advice to the NRIs is that if they have any such problems, such issues pertaining to their properties, they must approach experienced law firm, and that law firm can take the responsibility, can guide them, can help them out in getting back their properties, in getting back their funds, in getting back the damages which have been caused. So our advice is that you must approach experienced law firm, and for that we would like to end this session here. In case you have any other query, you can approach us at nrilegalservicesquery.com, and if any of the queries has not been left or maybe coming to us subsequently, we will separately be approaching those NRIs and replying to those queries. Any assistance we can provide, you're most welcome to approach our offices abroad. Thank you so much, and we wish you all the very best, good health and success. Thank you so much.
Thank you.
Thank you.
Thank you, Deepinder, and thank you.
Thank you, sir.